emojis from every other person. Okay. Okay, I guess we are on same page. Thank you. So I would quick be reading the citation of our our speaker. Okay, so mm, I apologize for technical issues. Okay, so I'll be reading citation of our speaker, Mr. Samuel Olugbenga Oloruntobi. Mr. Samuel Olugbenga Oloruntobi was born into the family of Mr. and Mrs. Lawrence Oloruntobi Ako of Igborupa, Akoko, Ondo State. He attended Margaret Lyons Nursery and Primary School, Ikare, Akoko, Ondo State, for his elementary education and was appointed a prefect in Primary 5 as a distinguished pupil. Mr. Samuel Olugbenga Oloruntobi attended Citadel International College, Ikare, Akoko, Ondo State, for his secondary school education, but took his West African Senior Secondary School certificate, known as WAEC, at Beaufort Model College, Ugba, Akoko, Ondo State. He gained admission to study law at the prestigious Obafemi Awolowo University, Ile-Ife, Osun State, and made excellent use of the rare opportunity by distinguishing himself in his conduct and knowledge, so much that during the final year dinner and award night of his class, which consists of over 370 graduating law students, he was given the prestigious Bookworm Award by his distinguished classmates, who are now all successful men in skirts of the bar. Samuel Olugbenga Oloruntobi proceeded to the Nigerian Law School and was called to the Nigerian bar in July 2018. He served his father's land under the National Youth Service Commission (NYSC) scheme in Kogi State and was a recipient of many recognition and awards during the 3 week long orientation camp, as he participated in almost all the extracurricular activities and excelled in them. After completing his 1 year service to his fatherland, he has since chosen to commit fully to litigation and courtroom businesses, where his passion primarily lies. Samuel Olugbenga Oloruntobi is a private legal practitioner, Christian, and a consummate family man who has been married to his lovely wife, Mrs. Oluwashikemi Oloruntobi, who is equally a lawyer since 2021, and together they are blessed with two wonderful children, Miracle and Ezekiah Oloruntobi. When Samuel Oloruntobi is not in court, he can be seen reading, exercising, watching combat sports, watching tennis, and discussing trending biblical entertainment and political issues with friends. And with the singular honor, I would love to bring our speaker. I expect us to be bringing all the emojis or the claps and everything as we welcome Mr. Samuel Oloruntobiloba for his presentation. Sir, can you hear me?
Yes, I
Okay.
can hear you very well. Thank you very
Thank
much.
you so much. We are honored to have you in the program, in the webinar this month. So over to you, sir.
Thank you so much. Good evening, everyone. I'm excited to be here once again. This should be my second time on this webinar series, and I'm so excited. In fact, I love this topic, and I intentionally picked it because it's a very important topic that has so much to do with the public. So many people want to know their rights as landlords, they want to know their rights as tenants to avoid dispute and to be able to navigate the very technical aspect of tenant and landlord relationship. So I'm so excited to be here, and I appreciate the host. I appreciate all those who have contributed to bring this program to life. So let us just start quickly because time is no longer on our side. As we all know, the topic for the webinar is tenant rights, explaining lease agreement, rules about rent increases, and how the law protects both renters and landlords because they both have rights. The right is not limited to one of the parties. Renters have their rights, the landlords also have their rights. And so we are going to be navigating very well what this right is all about and the pitfalls that we should avoid and what the law says about it. So the first thing I'll be talking about is that a tenant and the issue of lease or the issue of tenancy is actually a relationship built on rights and obligations. Rights and obligations. So every tenancy creates a legal relationship. There's a legal relationship being created, not just a personal arrangement between two parties. Once two parties come together to say, okay, I want to be your tenant, I want you to be my landlord, there is a legal relationship being created. It goes from just a normal relationship that people have. It becomes there's some legal obligation to be observed there. So and dispute over rent, we all know what a rent is. That's the money, the fee you pay as a tenant when you want to, be in possession of the building of someone. That is what rent is. So dispute over rent, repairs, and eviction are among the most common cases in Nigerian courts today. It's so much in court. I've done a lot of cases on rent, on leases. I've done a lot. I've done a lot. And I usually say, in most cases, when you go to court, the landlord takes the day. Not really maybe takes the day in the sense of winning or losing, but there is no day that the court of law will say the house that belongs to a landlord now belongs to a tenant. That will never happen. There may be an extension of a period of time. Maybe if the tenant claims that he made some repairs or he spent so amount on the building, the rent may be extended so that he may, of course, enjoy his own rights too to occupy the property at a particular time. But then there is no time they will now say the property now belongs to the tenant you get. So it's a kind of matter when it goes to court that you already know what the judgment you are going to get. Although the condition in which you are now going to get it may be different. But then you always know that the landlord will retain his house, except he's not the owner, except he's not the landlord in the real sense. But once he is the landlord or she is the landlady, he or she will retain the property. I hope we understand. So there is always dispute over rent, the issue of repairs and eviction. They are among the most common cases in Nigerian courts. You go to court every time. It's very common. You see people talking about the issue of 6 months. I have 6 months to to look for another house, things like that. We are going to dissect it very well to know what these things really mean. Many tenants and landlords act on assumptions. People assume a lot. They act on assumptions rather than what the law actually provides. And so I'm going to be telling us what the law actually provides. Let me quickly deal with one common assumption. A very common assumption that we see day in, day out in court is the tenant saying that he or she is entitled to 6 months, especially if such a tenant is an annual tenant, that is a yearly tenant, saying that he or she is entitled to 6 months, I'm entitled to my 6 months, is one of the biggest assumptions that we see today. And I know you guys will agree with me that happens a lot. But let me tell you that is not totally correct. Because when most people interpret this, they interpret it as though that 6 months is going to be free. That is, they interpret it as though they are going to live on another person's property freely for 6 months. The law never envisaged that. After all, it's not the government that builds the house for the landlord. The law never envisaged that. It's one of the biggest assumptions. What that law is saying is that you'll be given 6 months in the case where there is no agreement. If there is an agreement and you read the agreement you sign, and what is contained in the agreement is that you have only, let's say, 3 months, even for a yearly tenant, and you agreed, you read the agreement, you understand. I mean the tenancy agreement now, you understand, and then you now sign the agreement. You can no longer come back to the law to now say that you are entitled to 6 months, because by signing that agreement, your right to that 6 months has already been, you've already, it has changed. You've already waived that right. That's the word. You've already waived it because you read the agreement, you understand, and you signed. So, and what that 6 months really means is that even if there is no agreement, and now we go back to what the law really says, that you have 6 months, it's going to be 6 months that you will pay for. 6 months paid tenancy, you are going to pay for it. There is no free food even in Freetown in Liberia. There is no free food there. So you are going to pay for that 6 months. You see people going around saying they have 6 months as though they built the house for the landlord. It is not so. So it's one of the biggest assumptions that people come up with. You see people, even people that that know less about the law, they quickly say, I'm entitled to 6 months. You cannot just chase me out. Yes, you're entitled to 6 months if there is no tenancy agreement between you, but then you are going to pay for that 6 months. You are going to pay for that 6 months. I just say I should clear that before we go into other things. Then one of the things that relationship consists of, the relationship that is built on right and obligation, is that you have to understand your rights and how it protects you from exploitation and helps you to avoid costly dispute. I can tell you of a fact, tenancy dispute can be very, very expensive. I've done cases that the amount they pay, that is that the tenant pays, the rent now is about maybe 100,000 per year. And when the case came to court, I collected about 150,000. It's even more than the rent. That's what I charge. That's because the issue is now in court, and things can be more expensive. I am a paid professional, so I have to be paid to do my work, to represent the parties. So we can avoid all these things if we understand our rights and how we are protected. Then it helps to protect us against exploitations and all that. I need to point out now the difference between tenancy and lease. There is a difference between tenancy and lease. Tenancy is a situation whereby a tenant uses the property of a landlord for not more than 2 years. The contract usually lasts between a year and 2 years. It does not extend more than 2 years. Or even weekly, they are still part of it. A tenant is still part of tenancy from that to 2 years. 2 years is the maximum. Why lease takes off from 3 years and above. Even we as lawyers, when we do agreements, what we focus on, we are careful about the words that we use to couch it. When you want to do an agreement on tenancy, it has to be tenant and landlord. But when it comes to lease, it has to be lexi and lexor. I just wanted to point out that because we are going to be discussing lease and other things there. So the laws governing tenancy in Nigeria, we have so many laws governing tenancy in Nigeria. We have the state tenancy laws. The state tenancy law is largely the ones that are very effective, because tenancy is largely, mark my words, largely a state matter. Yes. For example, in Lagos, we have the tenancy law of Lagos State 2011. I also understand that just some weeks ago, there is a new law in Lagos that now says that A landlord can serve a 7 days notice, even if you are a yearly tenant, can now serve a 7 days notice to you for you to be evicted. It's a new law. So those laws changes, they are revised, new laws are created and all. So we also have the recovery of premises laws. States like the FCT, under the constitution, the FCT is structured like a state. So like the FCT, we have the Recovery of Premises Act to govern notices and repossession of property. We also have the common law principles where no specific statutes applies, the English common law principles can be applied. That is the English common law principles on tenants and landlord. They can still guide the court, especially in the way of telling them what to do, where we don't have a specific state law to show us the way. Then we can make a record to common law principles that can help. We also have the contract law. Tenancy agreement itself is a binding contract because it's between parties. And so ordinarily, rules of contract also apply alongside statutes. We have the rule of acceptance, offer, acceptance, consideration. If you look at all these elements of contract, they are also in tenancy agreement or lease agreement, whichever one that you really want to involve in. So let us go to what makes a valid tenancy agreement, or should we say elements of a valid tenancy agreement. Number one is parties to the agreement. The parties to the agreement must be clearly stated. It must be clearly stated the full names and details of the landlord and the tenant. I do a lot of tenancy agreement, so I know what I'm talking about. The premises must be specifically described. That is talking about the address, talking about the structure, whether it is a room and a parlor self-contained, whether it's a room self-contained, whether it's a three bedroom flat. So you as a tenant look forward to all these things in an agreement when one is presented to you. And if it is not really comprehensive the way I'm putting it, you may actually ask for the agreement to be reviewed, and the proper one should be done. Then we also have the rent amount and payment terms. So it must be there. The rent amount, that so amount is what you are going to pay. Then the terms in which you are going to pay it. Some people may accept that you pay it twice. So all those things must be there. Then the accepted method, whether by cash or by transfer, all these things too must be clearly, stated in the agreement. Then we also have the duration of the tenancy. When is the tenancy going to begin? When is it going to be terminated? This is also very, very important. When is it going to commence? And the length of the tenancy. Nowadays, you hear of landlord asking for 2 years, 3 years rent, mostly because of the economic situation. So the tenancy agreement must show in details the duration of the tenancy. What I often do is that when I make an agreement, yearly agreement, I extend the period to cover the years that the tenant is going to spend on the property, or the years he or she is going to use the property for. So that should also be very clear. Then the agreement should also contain the obligation of each party. What should the landlord be expected to do? What should the tenant be expected to do? And on the issue of repairs, maintenance, and conduct expected of both sides, because we all have obligations. The landlord has obligations, the tenant has obligations. So we must also make it very clear in the tenancy agreement or the lease agreement, whichever one it is, the obligations of each party. Then number 6, signatures of both parties. It must be there. It must be there as a matter of importance. It must be there. A written and signed agreement is best evidence in a dispute. It's the best evidence in a dispute. A written agreement. There is nothing like a written agreement. I know most of us remember the English adage that says that the faintest ink is better than the best memory, right? So the best evidence in court is something written, is a written and signed agreement, and the parties must sign. Signing by proxy is not allowed. The landlord must sign, the tenant must sign. So let us talk about the what the law guarantees to the renters, because we say both parties have obligations. So now we are talking about the rights of a tenant. The tenant has the right to quiet enjoyment of the premises without undue interference. This is very, very important. And for me, this is the most important. The tenant must at every time be allowed to have a quiet enjoyment of the premises without undue interference. Even according to the law, the renter at the point where he is occupying the property and his tenancy is still running, he is deemed, quote and unquote now, is deemed for that period, is deemed for that period as the one who possesses that property. So he's deemed as the one who possesses that property, which is very, very important. So we also have the right to proper written notice before any eviction. So he has a right. That's one of the most important rights of a tenant. He has a right to proper written notice before any eviction. He must be given a notice before any eviction. A right to be free from arbitrary or unreasonable rent increases. You know how common this is. A landlord just come and say, I want to increase the rent without even paying attention to the fact that he just increased it maybe some time ago. So it's very, very important. It's very, very important. It's one of the right of a tenant. The landlord does not have the right to just arbitrarily increase the rent each time he feels so, maybe according to the way he feels. Then the tenant also has a right to a habitable property that is fit to live in. Of course, even a very smart tenant, once you go to a building, it is expected that you inspect a building or an apartment before renting it, before even paying, so you know if it is fit for you to live in. Then there's also a right to a receipt for every rent payment made. This is one of the pitfalls. This is one of the areas that I see that most tenants don't take cognizance of. After they must have been given the key, most of the tenants forget to collect their receipt. Peradventure, if the matter goes to court, how do you show you've been paying? This is what most tenants does not think about. You must at every point in time that you pay, demand for your receipts from the landlord. The landlord has the right to give you a receipt for the money you paid. Very, very important. Then there is the right to privacy, as the landlord cannot enter without reasonable notice. Doesn't have the right to enter your property without reasonable notice. And this is one of the things, the points that the tenancy agreement or the lease agreement, whichever one it is, should contain. For that period that your tenancy runs, the tenant has the right to privacy, as the landlord cannot just enter the property anyhow. You see, like a lot of landlords, they like to trespass when it comes to this aspect, but they don't have the right. That's just the truth. So it's one of the rights that a tenant has. Okay, let us now move on to what the law guarantees to property owners, that is the landlord. Number one, the right to receive rent promptly as agreed in the tenancy contract. Yes, as agreed in the tenancy contract, the landlord, the property owners, yeah, we use those words interchangeably. They are the same. They have the right to receive their rent promptly, because of course, somebody that built his house and rented it out is expected to receive its should I say his income now, because for them is they spent on the property and they are expected to receive their rent. I have a friend that often tells me that the the real estate maybe not the proper one now, or renting out houses to tenants is not really profitable. Although that's subjective. That's not the reason why we are here for this webinar. The another right that the property owner has, that is the landlord, is the right to inspect the premises with reasonable notice to the tenant. Remember that when we're talking about the right of the tenant, we're talking about the fact that the landlord cannot just arbitrarily come to the property or just come inside the property as he wishes. But now we are also saying that the landlord has the right to inspect the premises with reasonable notice. I hope we can solve that issue now with reasonable notice. That's the most important thing. A reasonable notice must be given to the tenant before the landlord can do such. And I feel free to also say that the inspection must be carried out in good faith. There are some places that, as a landlord, just because you want to inspect, you cannot just enter, even though it's your house. But for that period, it is being possessed by the tenant. So, I want us to understand this and how it works. So we also have the right to, the landlord or the property owner also has the right to terminate a tenancy for a genuine breach of covenant. What is this covenant we are talking about? It is a tenancy agreement. You can see that the tenancy agreement is very important now. So that's what we are talking about. It is the tenancy agreement. So once there is there is a breach of covenant in the tenancy agreement, the landlord or the property owner can go to court, yes, to say, okay, I'm done. I can no longer allow this tenant to live in my house. He has breached this covenant, he has breached that covenant. And the court will uphold the argument because the court believes in agreement and the court believes that parties should honor their words. I hope you understand. Then there is also a right to repossess the property if due legal process is followed. Yes, he has the right to repossess. It's very close to also the other right we talk about, which is right to terminate a tenancy for a genuine breach of covenant. So the landlord also has the right to repossess the property after due legal process is followed. Underline it, due legal process. That is, he must pursue his grievances in the court of law. Then there's also a right to prescribe reasonable terms and conditions of tenancy. There are several conditions. Conditions like, okay, you must do this, you must, okay, clean the house, clean the compound, keep it safe, or, just, you understand what I'm saying, the conditions. So the landlord or the property owner has the right to prescribe a reasonable term and condition of tenancy. So the landlord or the property owners also has the right to seek redress in court where a tenant defaults or damages property. This is also very common. So the property owner has the right to say, my property has been destroyed, I want to seek redress in the court of law. So we are going to move very fast now so as to catch up with the time. So we have repairs. We also have the repairs and maintenance. Issues that deal with repairs and maintenance of property. Who is responsible for repairs? That's a very good question and a very common one that usually comes up in tenancy and lease agreements, tenancy relationship, lease relationship. So as a general rule, please underline the word general rule. To every general rule, there is an exception. As a general rule, the landlord bears responsibility for structural repairs, while the tenant handles minor day-to-day maintenance unless the tenancy agreement states otherwise. I told you from the very beginning that a tenancy agreement is what really defines, that's if they have one, is what really defines what the relationship is going to be. But in cases where there is no tenancy agreement number one, which I have advised us to always do, or the tenancy agreement does not cover that area, as a general rule, it is the landlord according to the law. I'm not here to be quoting laws for us because I know most of us are here to learn, to be practical with you. So the landlord bears responsibility for structural repairs. What is structural repairs? Maybe a part of the building goes down by natural cause. There is storm all over now, there is flood, we know what is happening in Lagos right now. All those things, structural ones, that is caused, especially caused maybe by natural occurrences. So it is the landlord that has the responsibility to take care of it. But there are some minor things that even commonsensically, as a tenant, that you should take care of this. That you should take care of this. Let me give you a very good example. Or just maybe the handle of your door, the doorknob, or the key, or those minor things, or just a small puncture in the window net. So you should be able to do that. It's not always you call the landlord. So this is what the law says about it, about who is responsible for repairs and maintenance. So the landlord's obligation is to keep the structure, the roof, and major fittings in a reasonable state of repair. The landlord has the right to do that one, or the obligation to do that one, because that's a big thing. Structure, that's to do with the structure of or the roof, or other major fittings. I know you understand what I'm talking about. So that's the responsibility of the landlord. It's an obligation of the landlord. The tenant should handle minor upkeep and avoid causing damage through misuse or neglect. You want to save the compound, you can call the landlord. So those things should be done by the tenant. When a landlord refuses to repair, what happens? A tenant may issue a formal written request. You must, as a matter of importance, learn how to write. Write letters, make everything written, so that when these cases get to the court of law, you have something to say. A tenant may issue a formal written request and, okay, even escalate it to a legal action if the landlord ignores. So you can go to the court of law, and the court will ascertain your right. And what should a tenant avoid? Avoid withholding rent unilaterally as a repair remedy without following proper legal process. Don't say because the landlord did not repair, I will not pay my rent. Two wrongs don't make things right. You understand? So you must, as a matter of fact, continue to fulfill your own obligation. That is when you'll be able to talk in court. That's when the court will be able to say you've done your part. So, let's go to the next subheading. Can a landlord simply raise the rent? This is also a very important question. Not arbitrarily. Not arbitrarily. Rent increase must follow the terms agreed in the tenancy agreement, not a landlord's sole discretion. The question should be, what of situations where there are no tenancy agreement? What happens? The same thing also apply. The test of a reasonable man. It is reasonably noted that at least if a landlord wants to raise rent, you should let the tenants know. You cannot just raise rent, or maybe you raise the rent last month, you raise it again this month. It's not reasonable. Some landlords, they have the habit of doing some minor structural, they can just they can paint the POP again. Maybe the POP, of course, most POP are white. They will now paint it with white again, with white color again, and then after that they increase the rent. This is not the way things should be. So you cannot just be increasing arbitrarily. The landlord cannot increase arbitrarily the rent just anyhow. Then we also have the mid tenancy limit. There is a mid tenancy limit. A landlord generally cannot increase rent in the middle of a fixed and subsisting tenancy term. You already agreed that for this year I'm going to pay 500,000 as my rent. Now in June, maybe the tenancy starts from January to December. In June, in the middle, you just say, Mr. Olontobi, you can no longer pay the amount we request. I want to increase it. No, that shouldn't be. If I thought there want to be an increase, it shouldn't be in the middle of a subsisting rent. You should wait till the end. Then we also have the rent tribunal. Some state operates rent tribunals or regulatory bodies that can review unreasonable increases. Yes, in my state, in Ondo State, there's a rent tribunal where the case of landlord and tenant go. In some southern states, customary courts deal with this. I know of Delta and some other states like that. It is their customary court that attends to rent matters. But in most states, in some states, let me say some states, we have the rent tribunal. Then there is a right to challenge. There is a right to challenge. A tenant who believes an increase is excessive or unlawful can challenge it through legal channels. Yeah, when we say legal channel, you should know that that's the court of law. So you can actually challenge it and say, why has it increased? It's like that. So let's talk about the caution fees, the agency fees, and other legal fees. The caution fee, a refundable deposit held against damage beyond fair wear and tear. It is not a form of rent and should be returned at the end of the tenancy if the property is in good condition. I hope you understand this. This caution fee is not to be taken away by the landlord. It is not an additional fee for a landlord. This one must be noted. For landlords who are part of this webinar, who are listening now, we must, even as a matter of morality, know that caution fee, and as a matter of law, caution fee is not for you to be taken away. It's not an additional fee. You collect it and you be waiting for the tenant to, or even praying for the tenant to destroy some of the things so that I can keep the caution fee, even if the destruction does not even is not up to what you have collected. Caution fee should actually be returned, but is it returned in practical? So I leave that for you to answer that in your mind. But the law says it must be returned once the tenant does not destroy anything in the house and leaves the property in good condition. The agency fee, these are paid to agents. We all know agents. They even have an association that, these agents have an association. They are the people that liaise between the landlord and the tenant. They are different from lawyers now. So they are the ones most time that let you know that there's a property somewhere. We all know of a picture that was going all about where they drew three people: the tenant, the agent, and the landlord. You can see the agent is fatter in the picture. I know we must have seen this picture on social media. That's because in most cities in Nigeria, the agents are fond of raping people. So I've even seen situations that the agents are collecting more than what the landlord is collecting. Is that fair? Is that fair? I leave that for us to answer. Agency fee is the amount paid to the agent, the person who is in between the landlord and the tenant. We also have the legal fee. This is paid for preparing or vetting the tenancy agreement. The tenancy agreement distinct from both the agency fee and the caution fee. I of course know that with my explanation we already understand the difference. The legal fee, as it's talked about, is what the lawyer collects. It's for the lawyer. Just like you say legal, so you already know that should be for the lawyer. Then how much notice is a tenant entitled to? How much notice is a tenant entitled to? Notice period generally depend on the nature of the tenancy. It depends on the nature of the tenancy, and I'm taking my time to break it down. Tenancy at will is only entitled to 1 week notice. I know the question that will be running in your mind is that what is tenancy at will? Tenancy at will is a tenant that whose time has expired, whose rent has expired, and is now at will of the landlord. The landlord can say today, leave my property, because after all, his money no longer runs. Our money no longer runs. So those are the category of people known as tenancy at will. And as a person of conscience, even before you get to that stage of being a tenancy at will, you must have know that you are getting into trouble and find a way to pay your rent. So immediately, when your rent lapse, it becomes a tenancy at will. So, and you are only entitled to 1 week notice. Then we have the weekly tenancy, 1 week notice, just like the tenancy at will. Maybe you are a weekly tenancy in a particular place. This is mostly common in urban areas. So you're only entitled to 1 week notice. And that 1 week notice, you will pay. Please, I want you to understand, even tenancy at will, for every day, every week you spend, every month you spend, you will pay. The government or the makers of the tenancy laws all over never intended that you should use the house of another person for free. Is that even fair? So they never intended that. They never intended that you will pay for the monthly tenancy, 1 month notice. For the quarterly tenancy, which is 6 months, there is 3 months notice. Then for the yearly tenancy, of course, the 6 months notice, and they are all paid. You must pay. It must also be noted that notices must always be in writing. That's one. It must be properly dated, number two, and served on the correct party. That's number three. This is also equally very, very important. So the eviction process, I know my time is fast going, but I will try to be faster. The eviction process, eviction must always follow due process. Number one, notice to quit. Landlord issues a valid notice to quit matching the tenancy type. I have explained the tenancy type before now. So, we have period. It must match that period. If it's a yearly tenant, except there is an agreement, it must be 6 months notice. If it's a quarterly tenant, it must have 3 months notice, and so on. Just the way I explained before now. Then should be a notice of intention. These are the notices that I should serve. There is a notice of intention. And when we talk about this notice of intention, we talk about the statutory notice of owner's intention to apply to court. It should follow. And that one is usually 7 days, even after the 6 months notice. Then we have the court application. If the tenant remains, the landlord applies to the court for recovery of premises. This is like taking the case to court. You understand? And in some cases, you may bring some application to court without actually filing a case. Let me give you an example. There is an application that is called that you can use to actually, go into your building if it is locked by a tenant indefinitely. So it can be, we used to call it application for force open. You can, if that is your situation, you can take that to court. Then we have the court order. When you take a case to a court, at the end of it, the court makes an order. And by this, you can use it to recover your premises. So what can a tenant do if wrongly evicted? Number one is damages. A tenant can claim compensation for losses suffered, including damage or missing property. I see this every time in court. That is, I always advise landlord not to go into the property of a tenant, especially when it's subsisting. Even if that tenancy is no longer subsisting, you must be very patient, because at the end of the day, if you forcefully, without court order, without applying to the court, you forcefully enter the property of a tenant, he can claim that he kept 1 billion naira in his house. How do you defend that? Because the question will be, did you enter the property? Did you enter it with the court order? So we must be very careful. Then when the tenant is wrongfully evicted, he can ask for an injunction. The court can order an immediate restraining injunction to stop further unlawful action of the landlord. Then the reinstatement, where appropriate, the court can order that the tenant be restored to the premises. Yes, that also exists in the court of law. Reporting to authorities. A wrongful forced eviction can also be reported to the police as a criminal matter. I hope you know. It also has its criminal aspect. What are the frequent disputes and now they get resolved? The common dispute that we have when we talk about rent and leases generally is that there is usually rent default or late payment by some tenants. Then there is damage to property. Some tenants are fond of damaging properties. Then there is often refusal to vacate after notice. Then there is unauthorized subletting, something that does not, that is not, the tenancy agreement does not allow. Then what are the paths to resolution? We have direct negotiation between parties. They can call each other and negotiate. Then we have mediation through a neutral third party, more like maybe an elderly person that knows about tenancy and all. Then there is state rent tribunals where available. Like in my state, I told you we have the rent tribunal that easily, resolves issues between parties. Then we have the court action as a last resort. You can go to court and just. I hope you also know that even the magistrate court in some states has jurisdiction over rent matters, especially if it is commercial rent. So you can also go there. What are the practical guidance for tenants and landlord? Number one, put it in writing. Very important. Always document the tenancy agreement in writing and keep a signed copy. Keep your receipt. I've talked about receipt. It cannot be overemphasized. It's very, very important. Receipt help to retain proof of every rent payment made, no matter how small. Know your state law. Tenancy rules differ by state, so confirm what applies where you live. Seek legal advice early. It is very important that you seek legal advice early, not when the trouble comes. You seek legal advice early. Consult a lawyer and be ready to pay consultation fee. Consult a lawyer before signing or terminating any tenancy agreement. A lot of us, we do as though we know we know things more than those who are really professionals. No, this is not okay. Consult a professional that can tell you, that can explain to you what the tenancy agreement contains and what it is all about. Then document property condition. When you get into a new property, when a world of video, social media and all now, take your phone, video the property in the presence of the landlord, so that you may know the condition in which you met the property, because you are not expected to improve the property. You are expected to leave it the way you met it, the way the landlord gave it to you. So if you feel you want to improve it, it must be on terms with the landlord, and perhaps maybe the amount in which you use to improve it be deducted from your rent. So the last but not the least is avoid self-help remedies. This is very important. I've seen so many clients come to me and say, lawyer, I cannot be patient, or I want to go and remove the roof of the tenant. This is in the case of a good landlord. I want to go and remove the roof of, I want to go and remove the roof of the landlord, the tenant. I want to do this, I want to do that. So never resort to self-help. This is very, very important. Never resort to forceful eviction or lockout outside the law. I want to lock the tenant out. I want to remove the roof. I want to remove the door. It is not proper. So I thank you very much for listening to this presentation, and I hope you've learned a lot. Thank you so much. Thank you.
Thank you, sir. We are grateful. Can we give applause, special applause to Mr. Toby Lover, Olaran Toby? Can we appreciate? Thank you so much, sir. We are so grateful for this insightful section. We are so grateful. And it's an honor to have you here, sir. So, thank you so much. So, basically, we have learned a lot. So, before we go into the question and answer section, sir, which you'll be helping us with, I don't know if anyone can unmute their mic and tell us what the length in the course of this section that we just had. If you can unmute your mic and indicate, so I can unmute your mic and let me know what you learned in the course of this insightful section. Does anyone want to help us with what he or she learned? We learned a lot now. I said all the mics should be unmuted. And can we hear me?
Yeah.
I, okay. So can anyone okay. I'm seeing the hands of favor. Yes. Favor, you can unmute. We are all here.
Okay, good evening. Thank you so much. I really learned a lot today, and it was like a refresher's course for me from, I think, property law practice class. And you also mentioned, I think what I really, really learned like newly for the first time today was you're saying if you go into when you want to rent a place, you can like take a photo or a video of the place so that you know how, like, to just have that evidence of what it was like before you moved into the place. So
Yes.
I think that's something new that I learned. But for everything else, it's a refresher. Thank you so much.
Thank you.
Thank you so much, Miss Favor. We are grateful. Yes. You can, our speaker said you should bring out your phone and take a video in the presence of your landlord. So your landlord will see with his eyes that, okay, sir, this is how it is.
Yes.
This is how it is. So, does anyone want to give us also, like, tell us what they learned also? It's a knowledge sharing class. Okay, I'm expecting more hands. Okay. So, so since, I don't know if does anyone want to share also. Okay, so I actually learned a lot. I think the practical guidance kept me on a very good spot. Saying we should put keep your receipt. If you rent a house, sometimes we once we collect the key, we already believe we own the house. So we should don't just collect the key, collect the receipt and keep it. I think that's one very important thing that I learned today. I learned the documentation is very important. Documentation is very important, very important. So quickly we'll be going into the question section. Does anyone have a question for our speaker? No, that's been insightful. So I know you may have had something new today, and then you're very inquisitive. Like, okay, what's this? What's this about? Does anyone have any question? Okay. We,
I think somebody is raising his hand.
okay.
Somebody is raising his hand.
Oh, can you mute your mic, sir? Can we have you, sir?
All right. Good
Mr.
everyone.
Tosin. Yeah.
Good everyone, and thank you to our guest speaker for today. I have one question actually.
Okay.
The agency fee, the caution fee, the legal fee, those fees should there be a receipt for it as well? Is it the right of the tenants to ask for those receipts? Because most times the agents they don't cater to put that in record at all. It's just the rent fee that they, they are concerned about. Those other fees are not on record. So does the tenant have a right to ask for a receipt for those other fees when you are getting a new place?
That's an
Okay,
amazing
thank you.
question. Okay. Okay, should I answer now?
Yes, sir. Yes, sir. Thank
Okay, thank you very much. That's an amazing question from Mr. Tosin. Ordinarily, for every money you pay for a service rendered or for a goods bought, you should collect a receipt. Ordinarily. But practically, when it comes to issues like this, agents don't give receipts. That's because, they you can ask for it, but I know in most cases they don't give receipt. That's because they are like a middleman between the landlord and the tenant. So the transaction itself, the tenancy relationship itself is between the landlord and the tenant. They are just a middleman. Maybe you allow me to speak pidgin. Their own is shop and go. Their own is shop and go. So once they are able to establish that relationship between the landlord and the tenant, and you are now living in your house, and they leave. They have actually completed their own. So in most cases, if you demand for it, you won't even get it. But of course, you have the right to ask for a receipt for every payment you make. I used to have a principal that usually say that even if you go to the market and you buy an handkerchief, you should collect a receipt. But me and you know that if you should go to a market now, or rather you and I know that if you should go to a market now and buy an handkerchief and ask for a receipt, nobody will give that receipt to you. So you understand. Thank you.
Thank you so much, sir. Thank you so much, sir. So please, I think okay. We have another question on the chat box. So the question says um when lease agreements contain ambiguous clause that both the landlord and tenant interpret differently, what legal principles do courts typically rely on to determine fairness, and how can both parties avoid such disputes from the outset?
Thank you very much. That's also a very good question, because more often than not you see things like this in court. When in law we have different rules of interpretation, and what the court will first do is to use the literal rule. That what does those words really mean? Like on their own, on paper, what does those words usually really mean? And so that would be the first way to interpret it. Because you try to interpret it just the normal English, and when it makes a reasonable sense, because you apply it. When it is not, when it is not actually supporting one side over another, in its pure sense, in its pure way, it will be interpreted that way. Once that one passes the reasonable man test, then that is what will be used. And how they can avoid it is that when you as a tenant collect any agreement, because usually the agreement is to come from the legal practitioner of the landlord, and in that from the landlord. So you ask, what is the meaning of this? What is the meaning of this? Seek clarification. And so when you are not satisfied with the meaning, you must, as a matter of importance, refuse to sign the agreement until you get what that word really means. So that is what is usually done in court. We have other several type of interpretation, but that's if the literal rule fails. If the literal rule fails, then we use other, canon. We used to call it canon of interpretation. But whichever kind of interpretation is used, it must be reasonable. It must pass the reasonable man test. Thank you.
Thank you, sir. Thank you, sir. Seek clarification before you sign, and it's the reasonable man test that is like the basic. Thank you so much, sir. So, okay, I'm seeing on that hand, Mr. Oluwatosin, you have the floor, sir. You can unmute your mic.
Okay, I have just one more question. Is there any law guiding the increment of rent? For example, some landlords have the bad habit of increasing rent very exorbitantly. Like you can increase rent for like 400%. Maybe you're paying 250 before, because I have a friend now. He's in this place, he pays 400 per year. And all of a sudden, the landlord increased it to 1.2. So is there any law guiding that in our country?
Thank you very much. Thank you very much, Mr. Oluwatosin. When it comes to increment, just like I said, or maybe to go straight to answering your question, there is no particular law that deals with the increment. There are laws that governs tenancy. There are laws that governs lease. But to now talk about that, maybe there's a particular law that will say in Lekki phase 1, the rent you must collect must not be above 2 million. Or in Akobo Olorunda in Ibadan, the rent you must collect must not be more than 1 million naira. There is no law that says that, because it is expected that for you that you want to rent an apartment, if a particular landlord calls an amount for you and you cannot, and is exorbitant in your own view, you should not take the property. It is not by force. And then even after taking the property, if the landlord does an arbitrary increase, you can leave. You can leave, because to some extent the landlord has right over his property. But that's not to say that he has the overriding power to continue to increase. So what you can do is to approach the court of law. The court of law as the as the most important body in justice, in decision like this, in the overall interest of justice, can now say, in this area, this amount is okay for you, and use the reasonable man test. We are still going to go to that. There is an amount, usually in every area, in every place that people live, there's usually something considered as being reasonable as rent in that area. What is reasonable as rent in Banana Island will of course not be reasonable as rent in Ikorodu or in other places. So you understand what I'm saying. Just like the landlord has the right to demand for a particular amount on his property, the court can still say, no, you are overcharging people. But that's if the tenant approaches the court. If the tenant cannot approach the court, then he may choose to leave the property to look for another one that the landlord can give him a more reasonable rent to pay and all. I hope you understand. But to answer your question straight, there is no particular law that will prescribe a so amount for a so area all over Nigeria. There is no such law. Thank you.
Thank you so much, sir. Thank you so much, sir. We are really grateful. We are grateful for this insightful section. We are really grateful, and I believe that's the same for everyone here. So I think we can show our appreciation with our emojis, the clapping emojis, the loves emojis. At least so I will know that you are all present. Thank you very much, Miss Clarity, Emmanuel, Oluwatosin. Thank you so much. So we are so grateful, sir. We are so grateful. It's a privilege and honor to have you this evening. We are so grateful, sir. So before I proceed, finally, does anyone have any questions? So I will not be hindering anyone from asking questions. Okay, okay, okay. So thank you once again. Thank you so much, sir. We are really grateful. So once again, this is the Know Your Right webinar, and it's held every month. Every month, um the next webinar will be holding in August. Next webinar will be holding in August, and it's hosted by okay, I think it was supposed to pop up on the screen, but by the way, so it's hosted by Excellent Legal Solution, headed by Barrister Ifeoluwa Aderogba. And I'm trusting God that we'll all be here next month. So the more details about the webinar will be posted on the group page. So if you have not yet joined the group page, please don't hesitate to do so. And also the slides for today's webinar will be shared on the group page. So you can do well to go over it again. And if you have any question, you can always reach out. I believe Mr. Oluwatobi will always be available to attend to any of our questions. Okay,
Yes.
thank you so
Always
much.
happy.
Thank you so much, sir. Thank you
Thank
so
you.
much, sir. We are so grateful. We are so
Thank
grateful. So we'll be wrapping up the this month section with a closing prayer. So
you.
can we just go ahead to prayer? Father, in Jesus' name,
Amen.
authority in heaven, we exalt your name. We thank you for this evening. Thank you for this educative section. Oh Lord, we pray that for the speaker who you have used, that more it will increase more in wisdom, in knowledge and understanding, and you will enlarge him and settle him in the legal profession. And we pray for as many that are here who have heard your word, that even both the landowners and the tenants and those who are tenants and will soon be landowners, will soon be landlords, that you will help us to implement this knowledge we have gained in today's meeting. Thank you, Father, for in Jesus' most blessed name we have prayed. Amen.
Amen. Amen.
Let's have a great evening ahead. Thank you so much. Thank you so much. Thank you so much.
Thank you.
Yeah, we can leave the call.